Florida sounds simple now, and that's the problem. People hear permitless carry and start acting like they can carry however they want. It doesn't. In Florida, the real danger is missing the line between legal carry and a charge.
Chapter 1. Carry Baseline. Florida is now being treated as a constitutional carry state. But is it? Some of the printed statutes still lag behind the way the state is currently enforcing the law. So if you qualify under Florida law, you can carry a firearm without a license, concealed, and now open. First, let's build the baseline by hitting age requirements. The permitless concealed carry lane generally requires you to be 21 or older. If you're 18 to 20, do not assume permitless concealed carry applies to you. There is one exception worth knowing here. Certain service members and honorably discharged veterans can still qualify for a Florida concealed weapons license even if they're under 21. But that is a license exception, not a blanket permitless carry rule for every 18 to 20-year-old. That rule is about carrying, not owning or buying. Hold on until Chapter 5 for purchase rules. So, concealed versus open carry. Florida used to ban open carry as a general rule. Then came the big change. In 2025, Florida's first DCA struck down the open carry ban as unconstitutional, and the Attorney General told law enforcement and prosecutors to treat the decision as binding statewide. The legislature hasn't formally repealed the statute yet. That's why what's written and what's enforced don't match as of the release of this video. But if Florida lets you carry without a license, why would anyone get the concealed weapons license? 3 reasons. First, reciprocity. A Florida CWL is recognized in a significant number of other states. Second, smoother purchases. A valid Florida CWL can exempt you from the standard waiting period at the counter, which we get into later. Third, legal clarity. Carrying under a license gives you a document baseline of qualification. In any interaction with law enforcement, that card does a lot of quiet work. Quick note on long guns. Rifles and shotguns sit in a different lane. Florida has no quote-unquote assault weapon ban and no magazine capacity limits. Long gun possession is generally legal for qualified individuals. The prohibited places list still applies, but the carry framework we're walking through today is primarily focused on handguns. Now, quick question for the Florida carriers watching. Now that open carry is being treated as legal statewide, would you actually do it? Or still carry concealed? Comment open or concealed. Personally, I'm staying concealed. Now that you know the baseline, the next question is where you can actually carry. Chapter 2. Prohibited Places. Even in a permitless carry state, location restrictions are where people mess up. Florida still has strict no-go zones, places where carry is simply not allowed under any of these rules. Think law enforcement buildings, courthouses, jails, government meetings, and polling places. But those aren't where most people get in trouble. Schools are one of the biggest traps. You generally cannot carry on K through 12 school property, but there's a narrow vehicle exception. If you're 18 or older, you can have a firearm securely encased or otherwise not readily accessible for immediate use inside your vehicle. That's how school pickup and drop-off is typically handled within the vehicle exception. Outside the listed school exceptions, the second that firearm leaves the vehicle on school property, now you've crossed the line. There is also a separate federal rule around schools that a lot of people miss. It covers the area within 1,000 feet of the K-12 school, but there are important exceptions, including if you are in your own private property or if you have a Florida CWL. If you are carrying without a CWL, the private property exception is your protection in that zone, not the license exception. Without a CWL, don't assume you're covered inside that 1,000-foot radius just because you're not on school grounds. That's why people who live near a school are not automatically breaking the law just by being at home or on their property. Now, a separate point. Florida's own 1,000-foot language is different. It is tied to exhibiting a weapon in a rude, careless, angry, or threatening manner near a K-12 school during school hours or school activity, not simple possession. Colleges are different, but still restricted with very narrow carve-outs. Now, here's the biggest trap in Florida. Alcohol. You cannot carry a firearm into the portion of an establishment primarily devoted to serving alcohol, the bar area, even if you're not drinking, even if you have a permit, even if you're just passing through. Now, restaurant usually equals okay. Bar section, hard no. Airports are another place people mess up. Once you get into the secured and sterile areas of the airport, the rules get tight fast. There is a narrow exception for a firearm that is lawfully encased and being checked for airline transport. If you're flying with one, keep it unloaded, locked in a hard-sided case, and declare it to the airline. But what about public areas like curbside pickup and drop-offs? That's a different lane. Outside the terminal restriction, but still dependent on you being otherwise legally allowed to carry. Private property is where a lot of people get overconfident. In Florida, businesses and property owners can prohibit firearms and they don't need a specific sign, or even a sign at all. If they tell you to leave and you refuse, it becomes an armed trespass issue. Now that's why assuming Florida is wide open everywhere can get you into trouble. Chapter 3. Vehicle laws and getting pulled over. Florida gives you a vehicle lane, but this is where people mix up lanes and talk themselves into trouble, thinking that having it in the car automatically means they can keep it on them. That's where the mistakes happen. So here's the split. If you're 18 or older and lawfully possess the firearm, Florida allows you to have it inside a private conveyance if it is securely encased or otherwise not readily accessible for immediate use. That is the vehicle storage lane. The other lane is this. If you meet the legal requirements to carry concealed under Florida law, then you can have a concealed firearm on your person while inside the vehicle. So the simple version is this. Securely encased or not readily accessible equals vehicle storage lane. On your person equals concealed carry lane. Don't mix those up. Florida also defines the terms. Readily accessible for immediate use means on the person or close enough and positioned so it can be grabbed and used as easily and quickly as if it were on the person. Securely encased includes things like a glove compartment, snapped holster, gun case, or closed box or container that requires opening a lid or cover for access. Then there's the parking lot issue. Florida's motor vehicle protection law generally prevents public and private employers from prohibiting someone from keeping a legally owned firearm locked inside or locked to a private motor vehicle in a parking lot when that person is lawfully present. It also generally prevents policies that require disclosure or allow searches of the vehicle solely for that reason. Now the traffic stop piece. You get pulled over. If you have a Florida concealed weapons license, you must carry your license and valid ID and present both upon demand. If you're carrying concealed without a license, you must still carry valid identification and present it upon demand. Florida is not a duty to inform state. You don't have to immediately volunteer that you're carrying. But if an officer lawfully asks for identification or gives a lawful command, you comply. So the smart move is simple. Stay calm, keep your hands visible, and follow lawful instructions. Chapter 4. Prohibited people. If you're prohibited, none of the carry talk matters. Not the permitless lane, not the car lane, not the sign argument. None of it. A lot of people think they're legal and they're not. Because Florida law is not just asking how you carry. It's asking whether you were allowed to have the gun in the first place. Florida ties permitless concealed carry back to the same legal standards used for concealed weapons licenses. So if you fall into one of those disqualifying categories, carrying without a license does not apply to you. Common disqualifiers include felony convictions without restored rights, certain recent misdemeanor crimes of violent or drug offenses, chronic and habitual substance abuse, certain mental health adjudications or commitments, some withheld adjudication cases, active domestic violence or repeat violence injunctions, and other conditions that disqualify you under Florida or federal law. Florida separately makes it a crime for felons to possess firearms, ammunition, or electric weapons. That restriction can also apply to certain juvenile cases that would have been felonies if committed by an adult while the person is under 24. Florida also has a red flag law called a risk protection order. If a court issues one against you, you can be forced to surrender firearms, ammunition, and any carry license while the order is active. Only law enforcement can petition for the order in Florida. Now, what do you think about red flag laws? Comment below. Chapter 5. Purchasing. Buying a gun in Florida is not complicated, but it can still bite you. When you buy from a licensed dealer, you fill out the required form, show photo ID, and the dealer runs a background check through FDLE before the firearm can be delivered. The response comes back one of three ways: approve, non-approve, or decision pending while FDLE reviews the background check. And here's the payoff from Chapter 1. If you're under 21, you generally cannot purchase any firearm, and a licensed dealer cannot transfer one to you. There are narrow exceptions like being gifted a long gun at 18, but for most people, 21 is the line. There was a push to change long gun purchase age to 18, but that failed to pass. Florida also requires you to be a Florida resident to purchase a handgun from a licensed dealer. Non-residents can buy long guns if their home state law allows it, but not handguns. Then comes the part people hate, the waiting period. Florida imposes a 3-day waiting period, excluding weekends and legal holidays, or until the background check is complete. Some counties also have extra local waiting period rules for certain sales. That waiting period does not apply to concealed weapons license holders and certain limited statutory exceptions. Private sales are where people get sloppy. Florida generally does not require background checks for most private person-to-person sales, but that does not make it a free-for-all. Age rules do not disappear, and neither do prohibited person rules. If you knowingly sell or transfer a firearm to someone who is prohibited, that is a crime. That includes what's called a straw purchase, especially if you're buying a firearm for someone you know is prohibited. But once you have your handgun, the challenge is not just owning the gun, it's carrying it comfortably, keeping it concealed, keeping it stable, and staying in the clean legal lane every day. Now that's where gear starts to matter, because a lot of people can legally carry. Way fewer people can do it comfortably, consistently, and without fighting their clothes every time they move. I'll hand it to Jane to show you exactly what comfortable, consistent carry actually looks like in practice.
Hey, if you made it this far, you probably care about doing things right. If you've tried carrying in gym shorts or sweats, it just never feels quite right. Waistband moves, holster shifts, it's fine, but it's not dialed. That is why we built Relaxed Fit Tactical. Our shorts lock onto an inner belt, so your holster clips to a hidden belt, not just fabric. Same setup, same draw, just more comfortable. So if you carry every day, this just makes sense. Links below.